The year is 1285. A full century before Shakespeare wrote Hamlet, King Edward I of England is faced with a problem. His royal physician has just died. Now, generally speaking, when someone dies, it's not the king's immediate concern. After all, everyone dies. That's just how things work. But in this case, the circumstances are different. The physician in question died at the hands of his apprentice, a young man named Hugh Despenser. But the details matter. See, Hugh didn't kill his teacher in a fit of passion. He didn't kill him in self-defense or in some other moment of need. No, he took the man's life for no other reason than he wanted his job. And then to make sure there would be no dispute over the position, Hugh poisoned the man. Poisoning, as everyone knows, is a particularly nasty way to go. And what's worse, it means the corpse might not even present any obvious signs of foul play. The only evidence of anything untoward happening is the testimony of the deceased's daughter, who claims her father told her he suspected foul play on the part of his assistant. At first glance, it looks like an open and shut case. Hugh poisoned his employer and should be held accountable. But upon further review, there's a fly in the ointment. Despite the obvious nature of his crime, Hugh is, as they say, protected by a technicality. You see, while poison is generally understood to be a bad thing, back in the 13th century, it wasn't explicitly illegal. Not yet anyway. Back then, a bit of arsenic was no more frowned upon than using a rusty knife to cut your bread. So because there's no precedent for trying a murderer on the charge of poisoning, you cannot be convicted of murder. This may sound ridiculous today, but it was a common problem back then. Medieval law operated according to a rigid set of precedents, and unless a crime was laid out in writing, it could easily slip through the cracks. Unfortunately for the dead physician and his grieving daughter, this particular loophole would become a rather famous case in English jurisprudence, a cornerstone, if you can believe it, of the development of common law. More specifically, it would serve as the foundation for the codification of a disturbingly callous legal practice. One that quantified the worth of a life, a practice known as white. To understand white, we have to get one thing straight. Life in the Middle Ages, especially in England, was cheap. Violent crime was rampant. It was the norm, not the exception. Men would regularly go toe-to-toe in public, beating each other senseless. While women were generally expected to keep the peace, they too were no strangers to physical confrontation, whether it be in defense of their honor, their children, or, well, occasionally just because they felt like it. Naturally, this resulted in a good deal of bloodshed and the occasional untimely demise. But medieval England wasn't exactly a lawless society. They had laws, plenty of them. It was just that, well, they weren't much of a stickler for things like due process or appeals. Just ask Roger D. Houghton, a chronicler who pissed off the wrong people and got executed for it. His assassin was actually put on trial, given a relatively light sentence of 3 years in prison, when he was found guilty. For perspective, the contemporary punishment for stealing a piglet was 4 times longer. So given the casual, even systemic brutality of the era, how did the courts decide how to handle a particularly brutal crime like murder? The answer is money. Well, technically, it was a system called Wergeld, meaning man price. And it worked kind of like this. When a person was killed, their family would receive a sum of money, typically paid by the perpetrator or their family, and tended to compensate for the loss of their loved one. It was basically a medieval insurance policy, but backwards. The entire purpose of the system was to keep tabs on interpersonal violence and ensure that feuds didn't spin out of control. If you killed a member of your lord's retinue, you had to pay him an amount of money, around 400 shillings, which was more than a peasant could earn in a lifetime. But if you killed a fellow peasant, you only owed the family of the deceased about 2 shillings and 8 pence, roughly the equivalent of a good night's lodging. As you might expect, though, there was a major flaw with this system. The price of a life varied wildly depending on who you were. If you were an impoverished widow, you might only be worth the cost of a flagon of ale. But if you were a duke, You might be worth a small fortune. This sort of thing tended to lead to disputes, not to mention some pretty grotesque attempts to game the system. At one point, a judge overseeing these payments apparently ruled that a dead wife was worth less than a dead horse. The rationale being that the family already received compensation for the former and wouldn't want payments for the same person. To prevent such insanity, King Edward I decided to formalize the system of wear a guild across the realm. And in 1285, he issued the Statute of Westminster, which listed the official value of every subject in England. The values were fairly straightforward. Members of the clergy were worth 200 shillings. Peasants, as a general rule, were worth anywhere between 4 and 50 shillings, depending on age and sex. Nobles were worth as much as 1,200 shillings. And slaves, surprisingly, were worth something too, usually around 60 shillings, roughly the price of a cloak. But there was one class of person whose price was left deliberately vague: women. The statute made no bones about the fact that female subjects were worth less than men. A married woman was worth half as much as her husband. An unmarried woman was worth half as much as a peasant. And the value of a widow was somewhere between 1/3 and 1/9 of her late husband's value, depending on whether or not she had children. No one knows why exactly Edward chose to marginalize women in this way, although it probably didn't help that the 13th century was not exactly the high watermark of feminist thought. The reality, however, was that women routinely had their value written out of the economic equation. They couldn't own property in their own name. They couldn't testify in court. And when they were killed, their families received just a fraction of the compensation that men did. Even a man who killed his own wife was required to wait 6 months after her death until he could remarry. As if that weren't enough, he also had to pay a fine to the king. And this, ladies and gentlemen, is where we get to white, which is Old English for fine. It was a payment to the king, a fee for the privilege of breaking the law and getting away with it. Technically, this payment was meant to compensate the king for the loss of a subject, a taxpayer and a soldier. But let's be real, it was really just another opportunity for the crown to exploit the unfortunate circumstances of a violent crime. So how much did a white cost? Well, again, the medieval mind liked to compartmentalize things. Women's lives were worth less, so their white was worth less. The price for killing a man varied based on his social standing. A peasant man might have to pay 20 shillings in white, while killing a nobleman might require as much as 100 pounds. By contrast, the fine for killing a woman was almost always less. In many cases, women were only required to pay half as much. But perhaps the most egregious example of this double standard came in the case of a farmer who killed a fellow peasant. He was only required to pay 12 pence for the privilege. But if he happened to kill her while she was in the bath, the fine went up to 40 shillings. Basically, the moral of this medieval morality tale is if you're going to commit homicide, make sure you do it in a socially acceptable manner. Don't worry about soaking the bread out of your victim. The law of white won't penalize you for it. Unsurprisingly, this whole system generated all kinds of problems. Henry VIII infamously exploited it to fleece nobles by having their sons falsely accused of murdering peasant girls, then demanding exorbitant fines. By the time of Elizabeth I, the cumulative effect of all these dubious calculations meant that the average white payment was running around £27, roughly 2% of the average male's annual income. But while this system was undoubtedly exploitative and deeply unfair, it was also remarkably consistent. From the highest rungs of nobility to the lowest hovel, the value of a woman's life was always the same less. Today, women's rights groups around the world have taken note of this shameful chapter in English law, and activists in places like Bangladesh and Pakistan have successfully lobbied to eliminate discriminatory laws that assign monetary values to women. But perhaps the most fitting conclusion to this sorry tale can be found in the annals of the law itself. In 1848, nearly 500 years after the death of Edward I, the English Parliament passed a series of reforms to bring the country's criminal code in line with more modern sensibilities. Among these reforms, the archaic law of white was finally abolished. And while this was certainly a progressive step, it wasn't exactly a complete victory. The old statute that assigned women half the value of men was replaced with a new one that assigned them 1/4 of the value. It took until 1996 for the last vestiges of this hateful legislation to be wiped from the books. In some ways, our modern world is a lot like medieval England, where even today, a woman's life is often measured by the size of her paycheck or the number of shares she owns. How much is a life worth? In some circles, the question is still rhetorical. In others, it's answered by a number. I'm the host. This was the Told Archive. And if you want to hear more stories like this one, don't forget to stay tuned.